Good evening and welcome. It is time once again for CU Immigration here on UPTV and or YouTube. We're not coming to you from our usual studio at the IMC because I was unable to get in to record the show, and so I didn't do the radio show this week. I'm just doing the video show for you. So this is not a WRFU production as usual. This is just coming from my home. I will be your host for this evening. My name is Mr. Garza, and I'm here to let you know that the views expressed are those of the speaker, in this case myself, and are not intended to represent UPTV, YouTube, or any other entity that may be involved in bringing this to you into your home. So these views are my own, and if you don't like anything I have to say, you can blame me. This CU Immigration is about immigration, and it's about immigration policy. So it does tend to be about politics a lot, and I find that very difficult in that trying to express how can I put this? Trying to express my opinions about immigration and the facts about immigration, and yet be somewhat neutral as required by the FCC, and given that WRFU is a nonprofit. I don't know about UPTV, but I'm assuming that it has similar rules about advocacy and things like that. It becomes very difficult to talk about this issue because the current administration has polarized it to the extent and personalized it in a way to the extent that if you are a supporter of a certain political party and a certain so-called conservative viewpoint, you are almost inevitably going to be in the position of feeling a kind of group responsibility to be against just about everything that I'm talking about. And so when I talk about immigration and I talk about what's going on and what I think should be going on and how all these things work together, I am almost inevitably going to be taking a position that becomes pro one sort of political party and anti another political party, because the parties have aligned themselves that way. I cannot be pro-immigrant and speak in favor of immigrants' rights and not be considered anti-conservative, basically. I mean, it doesn't work out. That didn't always used to be the case. The two political parties had differing views on a number of things, but they agreed on a number of things. And immigration was one of those things where it was seen generally as a good thing, a positive thing, something that needed to be controlled, something that should be seen as an area of concern at times when immigrants were like pouring into the country at greater rates than others. But it hasn't always been an issue that it has been so defining, or it hasn't been an issue that has been made to be so defining and so absolute in terms of what you could or could not support, accept, be involved in, or whatever. So I offer that as an extended caveat at the beginning of this show. I've discussed this before, but I've been thinking about it a bit, and it really does need to be said that my pro-immigration views, speaking on behalf of immigrants and for immigration, put me at odds with a certain current administration, and by extension, almost an entire political party. And as we grow closer to Election Day, it's going to be more and more difficult to talk about this without basically, by default, taking sides in the election and being a partisan player, so to speak. So take that as you will. CU Immigration is an outreach effort of the CU Immigration Forum that I am a member of. We are pro-immigrant. We seek to make our community, and by extension our entire country, a more welcoming place to immigrants. And therefore, we have been placed by holding that view, we are forced to be against most everything that is done by the current administration and by their political party. So it's not by design. I'll put it that way. We do not approach this with the thought, oh, we're going to be pro this party or anti that party. That has nothing to do with it. We are pro-immigrant, therefore we are anti-immigrant, if that makes sense. And that's just the nature of the beast right now. So bear that in mind as you listen to what I have to say. The first story that I wanted to read to you, we're going to be talking about immigrants' rights in this episode. So the first story I wanted to read is entitled, Trump's New Border Courts Are Designed to Fail. The Trump administration's latest efforts to block as many asylum seekers as possible from entering the U.S. have expanded exponentially with the implementation of port courts. Tens of thousands of refugees have been forced to remain in Mexico in order to request any protection from persecution rather than be permitted to enter the U.S. to await their hearing dates. For their hearings, they enter port courts, which are literally in tents and trailers that have been hastily put up in southern border cities. We are part of a group of attorney volunteers, the people who wrote this, who recently returned from assisting asylum seekers in Matamoros, Mexico. One of us accompanied 2 new clients to the port court in Brownsville, Texas. Neither the judges nor government attorneys are physically present, instead appearing by video and hidden from public view as press and observers are barred. The Department of Homeland Security, DHS, is solely responsible for this. The Department of Justice, DOJ, which employs the immigration judges, notes that the Justice Department will follow the regulation that requires hearings to be public. However, since DHS operates the port courts, DOJ has capitulated to the ad hoc rules which deny transparency. At every step of the way, refugees and the handful of attorneys who represent them are reminded that this system is designed to fail. There are no marked entrances to the Brownsville court, which resembles a concentration camp in its design and layout. Instead, attorneys must already know where the entrance is and ask to be let in by privately contracted guards who monitor it for the DHS. Forms with client signatures are required to gain entry. Attorneys are escorted by guards from the front gate to client meetings, to attend court, and even to access the restroom. Attorneys are not allowed to bring electronics into the tent complex, which means they cannot access their calendars or legal research. Meanwhile, DHS lawyers maintain access to their technology as they sit off-screen. Only the immigration judge and interpreter are video streamed into the port courtroom. In order to even schedule the next hearing, the attorney must request a recess so that they can leave the court complex, go to their car to access their calendar on their phone, and go through the security process all over again to get back to their hearing. Immigrants with hearings and their children are also subjected to security screening in order to enter. Their shoelaces are confiscated by DHS and not returned. Some refugees report being subjected to cavity searches just to attend court. Unless the immigrant is represented, the families wait for a group advisal of their rights, which is interpreted only in Spanish. Many refugees speak indigenous languages and have no way to communicate that in the face of a video link via a Spanish interpreter. Yet in order to secure a full hearing on their claim, they must submit applications, and all supporting documents are in English. Individuals with attorneys do not have their full hearings interpreted. At most, procedural matters are translated at the very beginning and end. For a client to know what is happening, their attorney must translate for them while making legal arguments and responding to the DHS attorney and the immigration judge. At the conclusion of one of our client's hearings, the contracted guard tried to force counsel from the courtroom without giving him an opportunity to explain the non-interpreted hearing that had just taken place. The attorney had to involve the judge, who intervened and asserted some control over the courtroom to allow our client access to counsel. Meanwhile, DHS's position is that attorneys have enough time to speak to their clients before the hearing and can meet their client in Mexico later to explain what happened. To meet with clients in Mexico, attorneys must violate the State Department's travel advisories, which categorize Matamoros as a level 4 security risk, which is the category reserved for the most dangerous places on earth, including active war zones like Syria. As volunteer attorneys were allowed to cross the border exclusively in a group during daylight hours, we conducted our work within 100 yards of the border crossing point, which makes client confidentiality impossible. In case of cartel violence, we were instructed to drop everything and sprint for the crossing on our group leader's signal. The harms refugees suffer due to our official U.S. government policy of rendering them homeless includes death by drowning in the Rio Grande, even while bathing, multiple documented instances of kidnappings within minutes or hours of being returned from the U.S. The toll of surviving on the streets of Mexico is amplified by the due process farce refugees face in post-courts. As tempting as it is, we cannot give in to our exhaustion and cynicism. We must hold this administration accountable for the ongoing illegality that is engulfing the border. It may take decades or longer to repair what we have lost under this administration, and there is no time to waste. I don't need to tell you that that sounds ridiculous. It sounds like something out of a dystopian science fiction movie, and yet this is how we treat refugees. These are not immigrants in the traditional sense of the word. These are not people who, like, hey, I'm coming here, I want to get a job, you know. These are refugees who are escaping violence, poverty, all sorts of things in their countries, and they're coming here asking for asylum. And we are treating them like criminals, like terrorists, like people who need to be shunned, like victims of some horrible communicative disease. That's how we're treating them. And this whole process is, to call it unfair, is just so mildly it's almost a joke to use that term, but it's ridiculous. It's intentionally abusive, and there's no other way to think about it. And this is what's going on. It's being done in our name, at our border, by the current administration, and with the compliance and I'm trying to think of the word, accomplices in this are the political party that supports this administration. They are accomplices. And that's the only way I can put it. I'm sorry. Anyway, moving on. Our next story is entitled The Fragility of Immigrants' Constitutional Protections. We've talked about this before. But it deserves to be said again, because in the last story we heard about refugees and how they are being treated. This is discussing immigrants and how they are being treated by the current administration. So this reads as follows.
Recent cases have claimed that our founding document doesn't defend non-citizens, even on American soil. On the night of July 27, 2017, police in the Memphis suburb of South Haven, Mississippi, responded to a domestic violence report. They went to the wrong address, knocked loudly, and a short time later shot through the door, fatally hitting the homeowner, Ishmael Lopez, in the back of the head. Officers later claimed that Lopez had pointed a gun at them. His wife, who was present, denies this. Those events are not before the Supreme Court this term, and they may never be, but the killing of Lopez and its aftermath illustrates the stakes in two cases the court will hear soon. Lopez's widow, Claudia Linares, has filed a $20 million excessive force lawsuit against the city. The city recently asked a federal court to dismiss it. Lopez, the city says, was an undocumented immigrant. Thus, Lopez may have been a person on American soil, but he was not one of we the people of the United States, entitled to the civil rights invoked in this lawsuit, the city said in a memo supporting its motion to dismiss the case. And thus he had no constitutional protection against unreasonable searches and seizures, or being shot to death is, in Constitution speak, a seizure. The 1990 Supreme Court case on which South Haven's brief relies, United States versus Verdugo Urguidez, is what I call an Inigo Montoya case. It does not mean what the city thinks it means. Verdugo Urguidez concerned a Mexican national who did not live in the United States, but who had been brought from Mexico to a U.S. border crossing by Mexican police and arrested by U.S. Marshals in the U.S. Then U.S. law enforcement personnel, working with Mexican police, searched two of his homes without a U.S. warrant. The homes, however, were in Mexico. The court held that Verdugo Urguidez could not invoke the Fourth Amendment right against unreasonable searches to suppress the evidence seized outside the country. It is, to say the least, a long way from federal agents can search a non-resident's homes outside the country to local police can kill immigrants living in the U.S. in their own homes 800 miles from the nearest U.S.-Mexico crossing. I stopped teaching immigration law years ago, so I asked my University of Baltimore colleague Matthew Lindsay, a scholar in the field, to assess the city's contention. Quote, "I don't even understand the source of the argument," Lindsay told me. "There are plenty of cases, including Supreme Court cases, holding that undocumented people do have constitutional rights." Mississippi authorities may feel some uncertainty about the 14th Amendment. The state did not even formally ratify the 13th Amendment outlawing slavery until 2013. But the requirements of due process of law and equal protection of the laws do bind Mississippi. And in the words of the amendment itself, both apply to any person within its jurisdiction. The framers of the amendment were clear that person was used in order to cover immigrants on American soil. Quote, "Every human being, citizen and stranger within your gates is under the shelter of the limitations of the Constitution," end quote. That was written by John Bingham, the principal author of Section 1 of the amendment, and explained while the amendment was being ratified in the states. The right at issue here, let's call it not being shot in the back of the head in your own home, is very much one of the due process rights that the amendment's language protects. But in 2019, the cheeky brutality of the no rights argument, you have to admire that Lopez may have been a person on American soil, has a certain deranged plausibility. The major immigration cases this fall, of course, are Department of Homeland Security versus Regents of the University of California and its two companion cases, which test whether the sudden decision by Donald Trump's administration to end the Deferred Action for Childhood Arrivals program, DACA, or the Dreamers program, was lawful. But two other lower-profile cases will shed light on how far constitutional limitations protect against government power in immigration matters. The first will be heard on November 12th, the same day as the DACA case, Hernandez versus Mesa, which asks whether there is a remedy for a Mexican citizen killed when a Border Patrol agent in the United States opens fire on someone in Mexico. Hernandez arises out of an incident at the border between El Paso, Texas, and Ciudad Juarez, a 30-foot wide culvert. Mexican teenagers were annoying the Border Patrol agent Jesus Mesa, Mesa, for reasons unclear, pulled his pistol and killed the 15-year-old Sergio Hernandez, who was hiding behind a culvert on Mexican soil 60 feet away. The Border Patrol's initial story that Mesa had been attacked by thrown rocks and in danger fell apart in light of cell phone video evidence. Since then, Sergio's parents have been seeking damages from Mesa in federal court. No statute specifically authorizes such a lawsuit, but in the 1970s, Warren Burger's court fashioned a remedy called a Bivens lawsuit for persons deprived of constitutional rights by federal agents. The issue in Hernandez is whether such suits should be available to a Mexican killed in Mexico by a federal agent shooting from U.S. territory. This case has been to the court before during the 2016 term. On that pass, the justices did not decide the specific question, but simply set out what they thought to be the correct standard for deciding the issue. Recent cases have held that Bivens suits should not be available if there are special factors counseling hesitation, the court said. The court remanded the case to the Fifth Circuit Court for a fresh look. After that look, the en banc appeals court, 13-2, decided that Sergio's family had no remedy. Allowing such suits increases the likelihood that Border Patrol agents will hesitate in making split-second decisions, Judge Edith Jones wrote for the majority, and threatens the political branch's supervision of national security. Now the Hernandez family has come to the Supreme Court again. The government supporting Mesa argues that the Supreme Court's attitude towards Bivens suits has changed since 1971, and that both foreign policy and national security concerns increase the need for caution before inserting the courts into such sensitive matters. Represented by the University of Texas professor Stephen Vladeck, the Hernandez family argues that there actually are no special factors to prevent Bivens liability. Courts hear law enforcement brutality cases all the time, they point out in their brief. Petitioners are pursuing a conventional excessive force claim against a rogue federal law enforcement officer. Unlike other cases that involve high officials or new constitutional claims, they contend, this case is squarely within established Bivens precedent. The second case is Department of Homeland Security versus Thuraissigian. I'm sorry, this name is hard for me to pronounce. Thuraissigian, which has not yet been scheduled for argument. The case tests a speedy deportation system called expedited removal, created by Congress in 1996, that gives immigrants few of the procedural guarantees of regular deportation proceedings. DHS currently applies this procedure to immigrants arrested within 100 miles of the border who cannot prove that they have been in the U.S. for at least 2 weeks. An immigration officer must allow the alien to seek asylum and prove credible fear of persecution in their home country. If the proof does not satisfy the officer, the alien can be deported more or less at once. No appeal to a federal court is permitted, with a small exception. An alien can seek release through an action of habeas corpus, the old common law writ challenging detention as unlawful. However, in these cases, the statute limits the court to asking 1, whether the individual is actually a citizen or has previously been given authorization by law to be in the U.S., and 2, whether a deportation order has in fact been entered. The immigration officer's determination is otherwise beyond review. Conspicuous by its absence is number 3, whether other provisions of the Immigration and Nationality Act should bar deportation. I'm going to have trouble with this. Vijay Kumar Thuraissigian, the respondent in this case, is from Sri Lanka and a member of the Tamil minority there. He was arrested a mere 25 yards from the border. Customs and Border Protection determined that he was not eligible for asylum, used expedited removal, and scheduled him for deportation. He filed a petition for habeas corpus arguing that the omission of number 3 renders the procedure unconstitutional. His argument is based on what's called the suspension clause, Article 1, Section 9, Clause 2 of the Constitution, which says, quote, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it," end quote. The Ninth Circuit agreed with Thuraissigian. It relied on Boumediene versus Bush, a key Supreme Court terrorism case. Congress, in the Detainee Treatment Act, had tried to oust civilian courts from any judicial review over cases involving Guantanamo Bay detainees. But Guantanamo, though technically in Cuba, is under complete U.S. control, the Supreme Court reasoned, and thus the suspension clause applied to prisoners being held there. Because the writ was not suspended, the court concluded that the Constitution required that those prisoners have a meaningful opportunity to challenge the legality of their detention. Thursingian was being held on the soil of the United States itself, the Ninth Circuit reasoned. If the suspension clause applied at Guantanamo, it must surely apply inside the U.S., his lawyers argued. The appeals court ordered the district court to permit Thursingian to contest the legality of his detention and impending deportation, the statute's language notwithstanding. In its petition for review, the government argued that the question has significant practical importance. It noted that thousands of aliens each year are ordered removed via expedited removal. Granting them unrestricted habeas review would significantly delay removal of aliens like respondent, preventing expedited removal of such aliens from being expedited at all and undermining the government's ability to control the border. Thursingian is represented by the American Civil Liberties Union. Its brief in opposition argued that given Belmedine and other precedents, a person detained within U.S. borders, he was entitled to invoke the suspension clause. That he was not legally admitted into the country does not alter that result, nor does the fact that he was apprehended only a short distance over the border. The practical importance of the case was greatly heightened on July 23rd when DHS announced a sweeping expansion of expedited removal. As practiced until then, the expedited procedure was applied only to immigrants detained within 100 miles of the border, and only if they could not prove they had been in the U.S. for more than 2 weeks. But under the new regulation, Immigration and Customs Enforcement will apply expedited removal anywhere in the U.S. to immigrants who cannot prove they have been in the U.S. for 2 years. The language of the Immigration and Nationality Act permits it. Thus, if full habeas review does not cover expedited removal cases, ICE agents may soon be able to seize immigrants anywhere in the U.S. and hustle them out of the country without any meaningful procedures. It's worth noting the ebbing tide of legality in this area over the past decade or so. The Fourth Amendment doesn't apply in Mexico. Fair enough. Next, Mexicans killed in Mexico by U.S. officers on the U.S. side of the border can't invoke the Fifth Amendment, searches and seizures, or the Fifth Amendment due process. That's a slight stretch. Habeas corpus doesn't apply to immigrants within 100 miles of the border. That's concerning. Now the government says that habeas corpus should not apply to immigrants anywhere in the country. Given this progression, one can almost understand why lawyers in a small Mississippi town might think that they can persuade a court to just junk the Constitution altogether. One prominent immigration law professor, Kevin Johnson of the University of California at Davis School of Law, sees in Linares' case a link to a darker aspect of immigration law history. Quote, "It's consistent with a long history of creating a Constitution-free zone in this context," he told me. "It all makes perfect sense if you think the Constitution shouldn't apply to people who are less than people." End quote. Well, I've run out of time for this program, and I had some more stories, but I will read them next week. But until then, I just wanted to point out that this creeping law